They are coming in.
How many people signed up?
We have about 30 people signed up.
Good.
So I want to thank all of you that have joined this webinar on what your family business needs to know about the Families First Coronavirus Response Act, and thank Mr. Rediger for sharing your expertise of what you're dealing with your clients right now and other family businesses. First, I just want to remind everyone that this is an educational program, and that it's not to be considered legal advice. To please speak with your personal advisors, your business advisors, when it comes to specifics related on your business. Rediger Labor Law is a law firm that limits its practice to the representation of companies in traditional labor law, employment litigation, and PAGA and class action defense. Mr. Rediger has litigated numerous cases in federal and state courts across the country, several of which have resulted in precedent-setting decisions favorable to employees. And so we're grateful to have you on board to share with us a little bit more about the Families First Act. And go ahead and take it away from here. Thanks,
Okay,
Bob.
thank you, Stella. What I'm going to do first is give everyone a roadmap as to what I'm going to be covering today. I'm going to start with an overview of the Families First Coronavirus Response Act, and you'll see that it includes two statutes or two federal laws. One is the Emergency Paid Sick Leave Act, and the other is the Emergency Family and Medical Leave Expansion Act. After we talk generally about the two laws, we'll talk about the federal regulations that are implementing the Families First Act. Then I'll talk about some specific provisions of that act as addressed by the U.S. Department of Labor, or DOL, in questions and answers that they've issued to help employers and employees interpret the act. Then I'll point out various links in my material that everyone can click on to get additional information at various federal and state agencies, then take questions and answers. And finally, I've included a poster that all covered employers should post regarding a summary of the act. So with that roadmap in place, why don't we first start by talking about the Families First Corona Response Act. And for those of you looking at the PowerPoint, I'm now on page 1 of my materials. On March 18th, this new law was signed by President Trump. It's effective from April 1st through the end of this year, December. You should know that for purposes of our present discussion, like I mentioned earlier, the FFCRA requires certain employers, and we'll talk about who's covered in a minute, to provide their employees with paid sick leave under the Emergency Paid Sick Leave Act, or expanded family and medical leave under the Emergency FMLA. Now, I mentioned the U.S. Department of Labor. Their Wage and Hour Division is the governmental agency that administers and enforces this new law. On April 6th, you could see here in my click on this first slide here, I've included a link to the temporary regulations that the DOL has implemented to implement the FFCRA. And under that, you could see that the DOL has also put up a web page where they have various questions and answers. They continue to add to this page. It's been updated about 3 times already. And at present, they have 79 questions and answers. So both of these links that appear on page 1 of my material are things that you should save. You can hit Control, click, and it'll take you right to those pages. But those are 2 very important pages. Also, one other note before we leave page 1 here. Depending upon where you do business, you may be covered by a local ordinance. So far, we've been talking about the federal law. For example, the other day in Los Angeles, the mayor Garcetti there signed an order. It's called the Supplemental Sick Leave Order. It became effective on April 10th. And this order will cover employers who employ 500 or more employees. You'll see in a moment when we talk about who's covered under this federal law, it's 500 or less. So my point is check any local ordinances to see if an ordinance or an order or something will supplement or cover employees that may not be covered by the federal law. Okay, so let's talk about the first aspect of the Families First Coronavirus Response Act, and that specifically is the Emergency Paid Sick Leave Act. Now, this law will cover private sector employers with fewer than 500 employees. And it will also cover certain public sector employees. And these employees that are covered under this law are eligible to receive up to 2 weeks of fully or partially paid sick leave for corona-related reasons. Now we'll spend a little time on this slide because you'll see that there's basically 6 reasons someone could get this benefit under this Emergency Paid Sick Leave Act. Sick leave is paid at 100% for those first 3 reasons on the slide there. So if the employee is subject to a federal, state, or local quarantine or isolation order, if the employee has been advised by a healthcare provider to self-quarantine, or if the employee is experiencing coronavirus symptoms. Under those 3 circumstances, the employee could receive up to 2 weeks of paid sick leave. It's paid at 100%, and you can see the caps there, up to $511 daily, or $5,110 total. The second group of reasons allow the employee to receive paid sick leave at 2/3 his or her regular rate. And that would be if the employee is caring for an individual subject to these quarantine or isolation orders, or he or she is experiencing any other substantially similar condition specified by the DOL. Just a note here, that phrase, substantially similar condition, has not been defined yet by the DOL. So for present purposes, just make a note there that that's an open question as to whether someone would qualify under that second reason there to receive 2/3 of his or her regular rate for emergency paid sick leave. And the last reason is the last bullet point on this page. Employees are eligible to receive up to 12 weeks of paid sick leave and expanded family and medical leave, paid at 2/3 their regular rate if the employee is caring for his or her child whose school or place of care is closed due to corona-related reasons. So that last point we just talked about makes this a little complicated because it's integrating not only the paid sick leave aspect of the Families First law, but also the expanded FMLA, which we'll talk about in a second. You'll also notice at the bottom of this slide here, I cited the regulation. And that 29 CFR, that stands for Code of Federal Regulation, and those are the sections that you would go to. You'll see at the in the materials, like I mentioned earlier, there's a link to those actual regulations, so you can key in on the page of the regulations and go to that specific section that I note at the bottom of this page and the following pages for more information. All right, so let's move to the next law that is part of the Families First Act, and this is called the Emergency Family and Medical Leave Expansion Act. Sometimes it's EFMLA. And let me make a few points here to put this into perspective. First, the FMLA is its own standalone law. It's the Family Medical Leave Act. California's version is the California Family Rights Act. Anyway, these 2 laws, FMLA and CFRA, apply to employers who regularly employ 50 or more employees. That law has not changed. That's still the same, whether you're covered by that it's still out there. The point of this new law here, this slide 3 that we're on here, the EFMLA, expands the FMLA to apply to employers with 50 or less employees only when an employee is on a leave to care for his or her child whose school or place of care is closed or whose child care provider is unavailable due to corona. So this new law now, this EFMLA, is not saying that the entire FMLA applies to every small employer. It's basically saying if you employ 500 or less employees, the law will apply only when an employee is on a leave to care for his or her child whose school or place of care is closed, as reflected in that second bullet point there. The third point I want to make is what appears in that first bullet point. The employees who have been employed for at least 30 days prior to their leave request may be eligible for up to 10 additional weeks of partially paid expanded FMLA leave if he or she is caring for a child. If the person qualifies for this leave, they are compensated at 2/3 of their regular rate of pay. Okay, let me move you now. That's an overview of the laws. These are the regulations issued by the DOL, Department of Labor, that will implement the Families First Act. So you can click on that link at the top. It will take you to a 125-page document, and these are the subjects referenced next to the numbers. So it'll give you an idea of if you're looking for something that might help you get to the precise section that you're looking for. And like I said, as we go further into my presentation, I tried to put at the bottom left-hand corner of each slide that regulation that you need to look at when we talk about specific subjects. And this would bring us into the DOL's question and answer webpage that I mentioned earlier. It's 79 questions currently that the DOL has posted with their answers. Now, the regulations are the law. The questions and answers are really not the law. It's just the DOL's best interpretation to help employers and employees understand, what Congress meant when they passed this law. So again, here's the link for these 79 questions. And like I said, it's very helpful. Now, what I've done next is go into specific subjects that I thought employers would find useful and important. The first one deals with who's covered, and you can see it's number 2. So if you go to the DOL website where they have their 79 questions and answers posted, number 2 will address the subject of who's covered. I've also, like I said, down at the bottom there, put the regulation where you could go to for additional information. You'll also notice at the end, I put 3 dots there after the word relationship. That's to show you that I did not include the entire answer that the DOL has on its website. You should be going to that website for the complete answer. What I wanted to do now is pull out those subjects that I thought were important, and I gave them the title at the top of the page, private sector employers covered by the FFCRA, because I thought this would be things that I could cover in this 45-minute presentation. So let's talk about first who is covered here. And we'll see that if you have fewer than 500 employees, and the key here is when do you measure it? At the time your employee's leave is to be taken. So this is important there in terms of when do you determine if you have 500 employees. So you look at the time the employee's leave is to be taken. And then the question and answer goes on to tell you who you would have to look at. You include employees who are on leave, temporary employees, if they're jointly employed by you, things of that nature. Like I said, the answer goes on further if this is a concern to you. Another interesting issue that everyone should be aware of is the small business exemption that exists under this law. We talked about earlier, the paid sick leave applies to employers if they employ 500 or less employees. Well, let's say if you say, hey, I can't be paying this, I can't be giving extended leave, it will bankrupt my company. Just so you know that the law says that if you're a small business and if this could jeopardize the viability of your business, you have 50 or less employees to begin with, begin documenting why your business would be threatened, because you could ask the Secretary of Labor for an exemption from the law. So not only should you be looking at question number 4 in the question and answer page, but also question number 58, where they go into detail there about the reasons that would let a small business claim the exemption. And you can see numbers 1, 2, and 3 there. The small business expenses and financial obligations would exceed their revenues. Granting this kind of leave and sick leave payments would entail a substantial risk to the financial health or operational capacities of the business. Number 3 deals with you not having enough workers who are able, willing, and qualified to work. And again, if you think this small business exemption may be something you're interested in, if you have fewer than 50 employees, go to that regulation I cited at the bottom, 29 CFR 82640, for more information on this potential exemption from these laws that we're talking about. All right, next topic that I pointed out in my presentation here is, what is an employee's quote unquote regular rate of pay for purposes of this Families First Act? And you can see the answer given by the DOL in response to question number 8 is you take an average of the employee's regular rate of pay for the last 6 months. And this way you can kind of average it out if the person's wage rate or salary fluctuated. Also, you would look at if the person's paid any commissions or tips or piece rate or anything else to come up with an average of actually, you would come up with what the regular rate is. And the regulation is at the bottom of this page. Next, let's talk about the records an employer must keep to claim a tax credit. Now, this could become very important because the way employers are going to get paid back, so to speak, for implementing these rules we've been talking about is to take a tax credit. And according to what the government's saying, it's going to be dollar for dollar. So if you pay out, let's say, $10,000 in this kind of sick leave and expanded family leave coverage, you should get that back at the end of the year when you pay your taxes. So at this point, you should note that there's a link in my materials, which we'll get to on page 21. It's an IRS form, and it deals with what material the government would want to show that you paid out money under these 2 laws to claim your tax credit. How about documentation an employee must provide the employer? Many of you probably already have a leave of absence request form that you might be using, and you could modify that. In terms of rules regarding a leave of absence under the FMLA, those rules wouldn't change for you. But for purposes of this law, if it's covering you when you were not covered by the FMLA, you would want to get whatever kind of documentation you would need to normally support an employee's request for a leave of absence. For example, if the employee says, hey, I need off because my child's daycare is closed, well, you might want to request some kind of documentation to back that up if that's what you would require, if you're not going to take the employee's word for it. The thing is, though, that all these requests should be documented. The DOL should be coming out with some forms to effectuate these leave requests, but as of yet, there's not a model form that employers could use. So just document it as best you can. Okay, the next subject I want to address is telecommuting, or as the DOL refers to it, telework. So the important thing here is if the employee can work at home and do his or her job at home, they would not be entitled to this kind of leave because they're still working, they're still getting paid, and all they're doing is working outside the office. So this person would not be compensated if they're working via telecommuting. Now, question number 19 there deals with the situation where the person first was able to telecommute, so there's no problem, they're still getting paid, they're still doing their job, and then they become unable to telework, and then they would qualify for these leaves. Okay. Next point I want to bring across to everyone is that the law is not applied retroactively. Like I mentioned at the very beginning of the presentation, the law became effective April 1 of 2020. So if an employer closed down its operations or laid people off prior to April 1st, they would not be entitled to these kinds of benefits under these laws because the law only became effective on April 1st. So that employee who was laid off, say, in the middle of March, would be entitled to go down and apply for unemployment benefits with the EDD, but they could not come back to you and say, by the way, I'd like to use some sick leave that is granted under the Families First Act, because they would not be eligible for that. And more information on that would be in question number 23 of the DOL's question and answer sheet, and also at that regulation there that I cite at the bottom. Okay, let's talk about paid sick leave under the paid sick leave law in addition to other leave entitlements. And the point I want to bring across here is that this federal law regarding paid sick leave is in addition to the employee's other leave entitlements. So if you have an employee handbook that grants employees paid vacation or PTO time or whatever, paid holidays, whatever other benefits you're giving to the employee, the Congress wanted to make sure that you weren't just substituting your paid benefits for what the federal government's giving the employees in the EPSLA. So these benefits here, if the employee qualifies, are in addition to those paid benefits that you may be granting. Leave under the Emergency Family Medical Leave Act may run concurrently with an employer's policy. So now we're talking about the expanded FMLA. And here the Congress had said after the first 2 work weeks of expanded family and medical leave, at that point, the employee's leave can run concurrently with any other leave of absence policies that you may have in place. So for purposes of the expanded FMLA, those that time off can run concurrently with existing policies you may have in place. You may want to note, though, that the employee has to be paid at least 2/3 his or her regular rate of pay. Okay, reinstatement rights under these laws. Generally, it's a protected leave of absence. And like all leaves of absences, whether it's jury duty or, whatever, CFRA or paid sick leave, the employee has a right of reinstatement. And generally, they have to be restored to their same or an equivalent position. So you can't retaliate or take adverse action against the employee because he or she has taken advantage of one of these benefits provided by the new laws. You'll note, though, at the bottom of the screen, it says, however, because this question and answer continues, it goes on to talk about what defenses the employer could raise if it's unable to reinstate an employee to his or her former position. And you can see down at the bottom of this slide here, it talks about, well, the position might not be available anymore, in which case you can't reinstate the employee because the position no longer exists. So keep in mind that if someone takes these benefits under these two laws, normally they would be entitled to their job back unless you can establish one of the defenses made available under the law. And that regulation there is something that should be looked at. Okay, the employee who decides to self-quarantine. I've been getting a lot of questions from my clients about this recently, where my client will call me up and say an employee doesn't want to work. They want to go home and self-quarantine. The question is this person eligible for these benefits under these laws? And generally the answer is no, because the law vests the healthcare provider with that discretion to make the determination as to who should self-quarantine. So the employee on his or her own should not make the medical determination whether they should not work or not. So again, questions 61 and 62 address this. And the point here is that the government wants a healthcare provider to be involved in this kind of determination. Okay, what about the employee who's on a leave of absence? Is this person entitled to any of these benefits that we've talked about under the law? And you can see the answer, it depends. And basically they're saying, is the leave of absence voluntary or is it mandatory? And I think what they mean here is if the leave of absence is mandatory, that means you've laid the employee off. Some employers are calling it furloughing the employee. Other employers are calling it laying the employee off. Here they're calling it a leave of absence that's mandatory. The point is that if the person's on layoff and when it occurred, will determine whether they are entitled to these benefits or not. Generally, the answer will be no. You're not entitled if you're layoff. If you're not working, you can't come in and say, by the way, I'd like to use sick leave. Okay, now this next page is very important because it contains numerous links to various places where you can find additional information. Like I said, the DOL came down with these regulations, and you can find them at that first link there. The Equal Employment Opportunity Commission, which deals with discrimination, retaliation, harassment, issues like that. A lot of issues have come up recently about testing. Can an employer test an employee before he or she is permitted to work, i.e. taking their temperature or things of that nature? And those questions and answers can be found at the EEOC website. There's also a wealth of information put out by OSHA, the Occupational Safety and Health Administration. I've given you their web page dealing specifically with COVID-19. OSHA's web page also has another web page actually dealing with the protective equipment that should be made available to employees, and that's at the bottom of page 20. Additional federal websites you should be looking at: the Centers for Disease Control, that's at the top of page 21. I mentioned the IRS with tax credits. They have an entire page set up with providing information as to how you would get a tax credit for any monies you're paying out to employees under these laws. And here's the form that you would use. IRS Form 7200, Advance Payment of Employer Credits Due to COVID-19. In addition to these federal resources, California has also put out various information on their websites. The EDD, that's where employees would go to file for unemployment benefits. They have an entire web page set up entitled Coronavirus 2019, and that's that page. They're very helpful. Cal OSHA, came out with its own page on guidance on requirements to protect workers, and that would deal with your PPE or protective equipment there. The California Labor Commissioner, which enforces wage and hour issues in the state, has come out with frequently asked questions on their website. And of course, the California Department of Public Health has their own website as well. Lastly, here we are with the employee rights poster. This is a poster that every covered employer should post at its workplace. I've given you the link there where you can download your own copy. A smaller version appears here. It summarizes kind of what we talked about in the first few slides here about what are the entitlements, what employees are eligible, and the 6 reasons we covered there for leaves. So it's all right in this poster. And like I said, the law says if you're a covered employer, post it. And that link should allow you to download it. Okay, so anyway, we went through quite a bit of information, and let me see if there are any questions that anyone has submitted, and I'll see if I can answer those. I did get one question here. I'm interested to know how the forgiven amount is calculated. Say we have 100 employees and furloughed half of them. Will we get 50% of what we do pay over the 8 weeks forgiven? What if we bring them all back by June 1st? How do we get the most forgiven, and how does that work? This question about forgiven really deals with the Payment Protection Act that was covered in the webinar last week, where a small business would go to a bank and say, okay, I need money to pay my employees, and the government says that amount of money would be forgiven if it was used for those purposes. The 2 laws we've talked about now don't forgive anything. Basically what they say is, okay, if you're going to pay your employees paid sick leave or extended family FMLA leave, you will get a tax credit. So the question basically is asking about, loan forgiveness to pay your employees, whereas these laws that I covered today, like I mentioned with the IRS forms and that page there, give you a tax credit for what you've paid out. So let's see, Stella, are there any other questions I need to address?
I have one for you.
Yeah.
This one is from Larry Jacobson, and he asks, he's an independent contractor and presents live workshops and presentations. Now all of my events have been canceled. Which program should I apply for? I'm an LLC, one person, thank you.
What program should he apply for? Well, again, this question I think would be more appropriate under the Paid Protection Act. He should go to the bank, complete those forms, and say, okay, this is the loan that I'm asking for these reasons, and I'd like it forgiven. But under these laws, he would have no employees. So no employee is going to be saying, can I take some paid sick leave, or can I take an extended family medical leave? So for purposes of the 2 laws I covered, there's really nothing for him to apply for here. If anything, he would go to the bank under the Payment Protection Act, or he should go down to EDD, because the CARES Act, I think it is, again, this is outside the scope of this presentation, I think the CARES Act is funding local unemployment agencies to provide benefits to independent contractors. So the best place he should go to start is that website that I referenced earlier for the EDD right here on slide 21, the California Employment Development Department EDD website on coronavirus, and see if independent contractors are referenced.
Thank you. I have another question for you. This one's about regular rate of pay. Does this include overtime or just the standard hourly rate of pay? If an employee usually works 10 hours a day, it says maybe use 50 hours in the first work week. So maybe pay them for 8 hours a day for 10 days.
Okay, well, the first thing I do is say, okay, let's look up question number 8 on the DOL website, because that tells you how to compute regular rate of pay. And I'd also look at the regulation there at the bottom of my slide 9, which references that exactly. Off the top of my head, I would say you would include the overtime, because you're computing the person's regular rate of pay based on what they were paid over the last 6 months. So you're going to be including things like commission, tips, piece rates, things like that. But what I would do is double check and see what specifically the regulation says about overtime. Off the top of my head, I'm not 100% certain. I wouldn't want to say without looking specifically whether overtime is referenced. Any other questions?
It looks like we're good. If anybody else has other questions, you can use the chat box below or the Q&A.
Okay, we covered a lot of material very quickly, and it's still evolving. The DOL's adding questions and answers to its website. So the regulations are termed temporary, so they could also change. This law was put together very hastily, and there'll still be a lot of questions, but this question and answer page on the DOL's website is very helpful in terms of providing guidance.
Thank you. Okay, so it looks like we don't have any more questions. This webinar is being recorded and we will have it on the website for you. We'll send you a follow-up email letting you know when that's available on our website. Next week, we're going to be talking with Nathan Tornes and talking about investing through crisis. Nathan is a member of the membership committee and he leads our member recruitment team. And so we're looking forward to hearing what he has to say about investing. And thank you, Mr. Rediger, for all of your time that you put this together for us. And I hope that it's a benefit to our family businesses and that we can continue to engage in this way until we can meet with each other in person.
Thanks a lot, Stella.
Thank you. And if there's any other programs that any of our members or prospective members would like to hear about, please let me know. Thank you.